And joining me now is senior advocate, member of parliament and someone who's been appearing for Uddhav Thackeray's team in the Supreme Court. Dr. Abhishek Manu Singhvi joins us. Appreciate your joining us, Dr. Singhvi. Am I right in interpreting what the court has done today, effectively ruled out the possibility of Uddhav Thackeray's chief ministership being restored? To that extent, your primary prayer that Uddhav Thackeray be reinstated as chief minister has been rejected by the court, and that's a setback for you and the Shiv Sena, your client, or the Uddhav Sena, your client.
Well, that's partially correct, but actually largely incorrect. And let me explain why. By one sentence preface, there are two historic judgments today, and the NCT judgment is no less historic, constitutionally even more historic. But anyway, let's come to Maharashtra. Rajdeep, the first answer to your question, and you have a right to be the devil's advocate and look at the glass 25% or 20% empty. The first answer is, what is left as far as the major legal issues arising in this case are concerned? Issue number one, is the whip by people other than the Uddhav faction valid? Answer, no, held illegal. Is the only whip recognizable that by the political party, that is the Uddhav Thackeray party? Answer, yes. Is the decision of the speaker recognizing the wrong whip and ignoring the right whip wrong? Answer, yes, the speaker is wrong. And fourth and most important, the base, the foundation of all this, the floor test, which you say that Uddhav Thackeray never attended. But the floor test is directed by the governor by a decision which stands quashed and declared illegal. The governor's decision to call for a floor test has been held to be without any objective material. So point number one is, you have lost ethically, morally, politically, legally, most of it. Now comes your question about resignation. Let me tell you, no doubt, the resignation has been made the basis of not giving the last relief after giving every major finding in the case in our favor. But there is a clear direction there that the speaker, the current speaker, must decide the matter within reasonable time, exact words. Now, let me tell you that if the speaker, Mr. Narvekar, picks up any of the disqualification petitions pending, and now pending for over a year, he cannot but decide only by disqualifying the persons. Why? Because these are persons who have now, in the light of this judgment, admittedly acted contrary to the valid whip. Admittedly, no adjudication can save that. Therefore, I predicted in my press conference today, Rajdeep, that what you will see now, the name of the game will change to either delay. The speaker will keep on deciding not to decide, or the speaker will keep on not deciding.
Sir, but either way, politically and legally also to some extent, this is a setback, because I come back to it. Your primary prayer was to reinstate Uddhav Thackeray. The court in its wisdom said yes, the role of the governor, has questioned the role of the speaker, but said because Uddhav Thackeray resigned prior to the trust vote, therefore they cannot reinstate Mr. Uddhav Thackeray, they cannot quash a resignation. No, 1 minute. Number two, they have ruled that it was right for the governor to call Mr. Eknath Shinde. Number three, and the reality on the ground is that Eknath Shinde enjoys a majority. So even if there was to be a floor test at that time itself, every likelihood is that Eknath Shinde would have won that floor test.
No, the last question doesn't arise. The first two questions all relate to what happened by him not participating in the floor test. I'm accepting that. I will agree with you readily that it's a setback of 25%. If you agree with me that 75% is a judgment in our favor.
It's the other way around. It's the other way around. It's 25% in your favor in terms of the moral grounds involved. But when it comes to your main prayer, it has been rejected.
No, listen. There are only 6 points rising in the case. Let's count arithmetic now. I'm joining issue with you because people should know. Issue number one, refer Nebam Rabia to a larger bench. Done. Issue number two, is the speaker's decision invalid? Held, yes. Number three, is the whip of the political party valid as opposed to the legislative party? Held, yes, all in our favor. Number four, is the governor's decision wrong? Yes, it is wrong. The only other issue which was left is that should it be restored status quo ante? Yes, against us. Now you count, out of 6 issues, 5 issues this way, or out of 6 issues, at least 4 issues this way.
No, what does the arithmetic tell you? Dr. Singhvi, but then Dr. Singhvi, look at it from an objective viewer standpoint. What has happened at the end of the day is that while the Speaker's decision has been held illegal, while there have been question marks over the governor's role, it appears that the court stopped
Not
short.
question mark.
No, the court
Declared illegal.
declared illegal. The court has stopped short of doing what you wanted, and as a result, the ball is now in the Speaker's court. The Speaker can take his own time. Elections are in Maharashtra next year. Effectively, as Eknath Shinde says, he is going to continue Chief Minister. Nothing is going to affect his government.
We are not saying that legally the court has unseated you. Let's be clear. Have I said that? I'm only saying two things. Anybody without a thick skin and anybody with any shame would realize that they have lost morally, legally, politically and every other way on every count, barring this. Doesn't mean you have to resign.
No, so are you saying that on moral ground you want Eknath Shinde, you believe, should resign after this court verdict?
No. I am saying that the whole population of Maharashtra and India has seen how a meddlesome central government acting as the master puppeteer has treated governors, speakers and minorities in terms of legislative minorities as puppets and pulled them this way or that way, all of which has been held to be illegal by the Supreme Court. I am equally saying that if the Speaker was to take up the pending disqualification petition as directed by the Supreme Court, no power on earth can prevent these people from being disqualified unless the Speaker in a premeditated system gives a wrong decision. We challenge that and that will be set aside. Because I'm telling you this, the Speaker must decide that you are disqualified because you violated the whip. If the Speaker doesn't do it, the court will do it.
But the court has not given any time frame for the same, and therefore there will be a question mark whether the court actually wants to intervene beyond the point on issues that are in the domain of the Speaker as per 10th schedule. What has happened is the court has gone far, but many will say not far enough. Would you agree or not?
Certainly, I would agree with that last sentence. Ideally, we would have want all 6 reliefs, and I'm saying we've got 5 or 4 out of them. But let me tell you, reasonable people understand the meaning of the sentence, must decide in a reasonable time. Unreasonable people, which I believe is the category to which this category, the respondents in the Supreme Court belong to, do not understand what reasonable time means. So if you decide not to decide, we will go to court. If you decide to delay the decision, we will go to court. If you make a patently wrong decision, we will go to court. What will happen? We are only delaying the inevitable. But the point is not chief ministership. Rajdi, the point is, look at how exposed you are before the public. It's a shameless, naked display and usurpation of arbitrariness, of high-handed action, unconstitutional action by people sitting in Delhi, right through the governor, right through the speaker, right through the lesser majority in the assembly.
Can I therefore ask you in conclusion, Dr. Singhvi, Eknath Shinde says the original sin in a way was committed by Uddhav Thackeray when he chose to break away from the BJP after the election. He also claims in a press conference today, look, at the end of the day, the majority of the MLAs were with me. Therefore, all this talk of moral grounds on which I should resign are all rubbish. The truth of the matter is I had the majority of MLAs with me, and Uddhav Thackeray is the one who committed the original sin by breaking away from the BJP.
See, we are not having a divinity class about original sin. We are certainly having a judgment to read. If what Mr. Shinde says is correct, then what is the purpose of the Supreme Court devoting some 200 pages to give 5 out of 6 findings in our favor? According to what you just quoted Mr. Shinde saying,
yes, everything
is hunky-dory. But I've just told you, please refute me if you can from any para of the judgment. 5 out of 6 findings are all in our favor. All that you are saying is that because time elapsed 1 year, because he did not participate. Remember, the basis of that non-participation is the direction to hold a floor test. That direction has been held to be illegal.
So you're saying that your client, Uddhav Thackeray, resigned voluntarily because he did not want to face a floor test, which was in itself illegal as per what the Supreme Court has said. And therefore, you believe now the ball is in the Maharashtra Speaker's court, and the Maharashtra Speaker must decide expeditiously on the disqualification petitions, failing which you will go back to the Supreme Court.
and that once the whip has been held valid by this court, that's the most important takeaway, the speaker in any reckoning which is fair, reasonable or bona fide cannot but decide that these people are disqualified.
Okay.
Because they violated the whip of the political party which has been held to be the only valid whip.
Okay, point taken. We'll see what the implications of this judgment are in other defection cases across the country. But for today, it is an important judgment that has been delivered by the Supreme Court. Appreciate your joining us here, Dr. Abhishek Manu Singhvi. Thank you.
Thank you.